Welcome to EPG Pathshala. This paper is the philosophy of law. The present module is entitled Death Penalty. The objectives of this module are to understand ethical theories that support the death penalty and to understand the death penalty in the Indian context. This module was written by Bharat Kumar from IIT Indore. I'm Akash Singh Rathore from the Lewis University of Rome. Let's begin by discussing the ethical justification of punishment. A crime, when it's committed, ought to be punished. Now, we normally say that two wrongs don't make a right. A crime is clearly a wrong. For the punishment to not be just another wrong inflicted upon the person who commits a crime, we require an ethical justification for that punishment. Otherwise, if we saw the punishment as just another wrong inflicted on someone who did wrong, we could never produce a right. A crime ought to be punished. One who suffers wrong is not degraded by suffering that wrong. However, the one who does wrong has lowered himself on the scale of moral perfection. A man is rewarded for his good deeds, and similarly, a man must be punished for his evil deeds. A criminal has voluntarily violated both the moral and the legal code, and that, in its recognition by society, requires or demands some sort of response. And this we know as justice. The majesty, the dignity, the authority of law demands punishment. Now, how is it that we understand the type of punishment that is meted out? How do we understand, according to our dominant moral theories, the justifications for that punishment in more precise terms rather than in these general terms that when a crime is committed, a wrong is done, and that wrong needs to be rectified in some way? There are primarily three ways in which we think of rectifying that law, and these are three different sorts of theories of punishment. The first one is referred to as preventive or deterrent. To deter means to abstain from. So the main objectives of this theory is to deter or to prevent crimes. In other words, preventing people from committing the same act that was done, the act that we're punishing. It serves as a warning not only to the offender, but to everybody else in society not to repeat this same sort of crime in the future. So you can see the deterrent or the preventive theory as using the criminal for the larger good of social welfare. A person, let's say, has committed a murder. We want to ensure that people in society at large don't think that this is a good example and that they can carry out murders as well. We want to ensure that through the punishment of this murderer, other people are deterred from doing murder. They'll restrain from doing murder or refrain from doing murder because they see what kind of punishment is meted out to a murderer. So in this respect then, the punishment is justified for the social good that it brings about. The punishment is not directly targeted at the individual, but the justification of the punishment is more targeted or directed towards the common good. Well, that suggests that the aim of this punishment is to make a means out of an individual. People are not things. Things are things that we use for our own end, that we manipulate for our own purposes. But a person is fundamentally an object of dignity, so not something that we can just use for our own means. This creates problems for this deterrent theory because the deterrent theory clearly uses the punishment of an individual as a means to deter other people, and this violates our basic understanding of human dignity, which is to always treat a person as an end in himself and not merely as a means. This deterrent theory of punishment sees quite a lot of criticism from people with a deontological moral view, that is to say, people who view the human as an end fundamentally dignified end that can never be exploited just for other people's benefit. The second theory attempts to address this problem of the common deterrent theory, and it's referred to as the reformative theory. Now, according to this theory, the aim of punishment is to reform or to educate the offender himself. So rather than concentrating on the social good first and foremost, it concentrates on the good of the person who committed the crime. We attempt to reform that criminal so that he is not the sort of person who would commit crime in the future. He might, as a consequence of the punishment, repent for the crime that he's committed, see that it was a wrong, see that it's the wrong behavior that he himself now disapproves of, and therefore prevent any such crime from happening in the future. This sort of reform is, of course, concerned with the dignity of the criminal. A criminal is punished for his own good and not merely for the good of others. As you can see clearly in this case, the person isn't treated as a means, he's treated as an end in himself. Now, the idea behind a reformative theory is that criminals are basically human beings just like the rest of us. No one is born a criminal. The criminal is a product of his social, economic, and environmental circumstances. The environment, the political society itself, constructs the criminal out of the basic human material. So it's believed that if criminals are educated, re-educated, properly trained, they can be made competent to behave in a just manner in society. Now, the theory of reformative punishment is seen by several as missing out on one crucial aspect of justice. That is, that the victim of the crime might feel that justice has not been done. Whereas in the first theory of deterrence, we realized that the concentration is on the polity or the community. In the second theory, the concentration is on the criminal. What about the victim? What about justice for the victim? So we have another theory referred to as retributive. And the retributive theory broadly keeps in mind the sense of justice that is required to be felt by the victim of a crime. The retributive theory of justice is based on a very old principle that was stated thousands of years ago in various civilizations like Babylon, Mesopotamia, and appears in the Old Testament, and everyone has heard it. An eye for an eye, a tooth for a tooth. In other words, if one person should take out the eye of another person, that person's eye should be taken out. So this is a strict reciprocal retribution of justice. We're not worried about society at large. We're not worried about the welfare of that criminal. How can you be if you're plucking out his eye? What we're worried about is that a wrong has been done, a person has suffered from it, and the person who committed that wrong must in turn suffer. And only in this way can the victim of a crime feel like justice has somehow been returned. The object of this theory is to make the criminal realize that suffering some kind of pain is precisely the pain that he had imposed on the victim. This theory then takes a kind of revenge. It's not worried about transformation of the individual, it's not worried about social welfare, it's just concentrating on righting the wrong through a kind of revenge. Obviously, the retributive theory of justice suffers most of all from the defect of two wrongs don't make a right. The criminal had done a certain wrong by taking out the eye, but is the mere vengeance of taking out the criminal's eye not another wrong? And do we get right out of these two wrongs? Well, all of these theories are debated for such considerations. Each of them has its strengths, each of them has its weaknesses. One point that we should realize is that in theories of punishment, unlike in moral philosophy as such, these different theories can be mixed and matched and suited to the occasion. So one of the greatest defects from the moral philosopher's point of view is to mix deontological or principle-based theories of morality with consequentialist theories of morality. In other words, a deontological principle would be, don't treat a person as a means, but treat them as an end only. But a utilitarian perspective, let's say one that's interested in the good of society, is very comfortable with treating people as a means and not just as an end. So in moral philosophy, we distinguish radically the deontological from the utilitarian. And debates in moral philosophy have largely been conducted through a quarrel between these two sorts of perspectives. But in adjudication, in jurisprudence, in legal theory, we don't have that sense of purity and cleanliness between the theories. They can be mixed and matched. And just so, when a judge sentences a criminal to a certain penalty, that judge might, in his argumentation, mix both deontological and consequentialist concerns. In other words, the judge might say, a crime has been committed and this wrong must be corrected. This wrong should be corrected for the good of the criminal, a deontological position, to rehabilitate the criminal. This wrong should be corrected to prevent other people in society from committing such a wrong in the future. That's a consequentialist, welfare, sort of utilitarian argument. And this wrong should be prevented because the victim must see justice. So what the judge has done is he has mixed together three different moral conceptions that within moral philosophy itself, any moral philosopher would definitely say they must be separated. This is a fundamental difference between the philosophy of law and moral philosophy. Philosophy of law is much more pragmatic and has to deal with real-world situations, whereas moral philosophy idealizes the conception of moral thought and the different moral philosophies, and in the process of that idealization demands a higher level of purity than we can actually expect in the real world. Now, moving on from these theories of punishment, let's go to the very specific, concrete case of the death penalty. The death penalty, also known as capital punishment, because it is the foremost or the capital punishment that can be met with, is the act of killing or executing a person who was found guilty of a serious crime, obviously through due process of law. So it's not capital punishment if the guilt is not found through due process of law. That's murder. If guilt is found through due processes of law and the person who committed the crime is sentenced to the death penalty as a consequence, then this is capital punishment. Now, without a doubt, executions are considered the ultimate punishment for a crime. For any other punishment, the offender or the criminal can always appeal and undergo processes of appeal to higher courts of jurisdiction. For example, if a district court sentences you to a certain amount of time in jail, you can appeal that to a higher court. If the higher court upholds the district court, you can appeal that yet again to the Supreme Court. And let's say that the Supreme Court produces a judgment that is very harsh or questionable, you could even take that to an international tribunal. But where are you going to take the death sentence? Once you're dead, you're dead. It's over. It is the highest and most extreme form of punishment known to civilized legal systems. Obviously, there are other extreme sorts of punishment, such as torture, but civilized legal systems generally outlaw these. The death penalty is highly contentious. Many countries around the world have abolished the death penalty primarily because of humanitarian concerns. But there's also another concern that goes into the abolition of the death penalty. After all, there is no appeal to the death penalty, as we've just mentioned. So what if the due process of law is found later to have been flawed? In fact, there are many cases that come out where after a certain amount of time, the execution has already been performed, a witness reveals that the case was not properly carried out. The accused person was not at the scene of the crime after all, or something of that sort. In cases such as this, you cannot correct this mistake. The state has already taken a life. This is one of the other concerns, concern with due process, along with the basic humanitarian concern about whether we should have the death penalty. So a number of countries, in fact the entire European Union, has abolished the death penalty. But there are an equal number of countries that have not. The United States and India, for example, being two prominent ones that routinely carry out executions. So let's turn to the death penalty in India. In India, the death penalty has been prescribed for several crimes such as murder, gang robbery, along with murder, abetting the suicide of a child or an insane person, waging war against the government, abetting mutiny in the armed forces, and at various times the penal code has been modified in order to incorporate new justifications for the death penalty, for example, gang rape with murder and so on. However, Section 3543 of the CPC, the Criminal Procedure Code, which was added in 1973, requires to give the judge special reasons for awarding the death sentence. In other words, the condition according to which a judge can offer the death sentence is a heightened scrutiny. So the judge needs to write a speaking order with special reasons for giving the death penalty, rather than simply saying, well, the IPC mandates in this case that the death penalty is permissible, therefore I award the death penalty. You need to move between the permissibility of the death penalty to the reasons why we give the death penalty, and this was written into the CPC in 1973. Further, the Supreme Court in 1980 propounded a new doctrine. This new doctrine is referred to as the rarest of rare doctrine, and this happened in the well-known Bachchan Singh case. Since the Bachchan Singh case in 1980, the life sentence has been the rule and the death penalty has been the exception. Notwithstanding the rarest of the rare doctrine, or also known as the Bachchan Singh standard, a large number of convicts are routinely awarded the death penalty in India. However, the actual carrying out of executions is very rare. The reason for these reaching standards such as the rarest of the rare is, of course, the basic law, the Constitution in Article 21, which states, "No person shall be deprived of his life or personal liberty except according to procedure established by law." So Article 21 has a high standard by stating that no person shall be deprived of life. So the procedure established by law needs to be clear and justified. The reason that the Law Commission concludes that the order of a judge should be a speaking order giving its reasons is that the judge's job is not to make law. The judge's law is to interpret and see that the law is implemented. If the judge were to decide arbitrarily that this should be the death penalty, this should be life in prison, then what the judge is basically doing is usurping the legislative function. It should be the legislature that decides which cases lead to the death penalty and which cases do not. The IPC is quite clear about which crimes are subject to the penalty of death. But as with all crimes, the punishments that are written for various crimes within the IPC are specified not as mandatory, but as advising a scope of maximum and minimum. In each case, let's say for the crime of murder, you have a minimum punishment that must be meted out. But there is also the maximum that can be meted out. In the case of murder, there is, of course, the death penalty. So who is it who's to decide between the minimum and the maximum? Obviously the judge, because the judge is there to hear the particulars, the facts, and who applies the legal principles to the facts of the case. We can't bring each case of murder before the Parliament for the Parliament to decide. So the judge is necessary in this process of meting out the punishment. At the same time, we have to ensure that the judge doesn't act arbitrarily. The judge doesn't act willfully. After all, part of the rectification of crime, part of making the wrong right, is the fact that the punishment is not meted out in a vindictive and arbitrary manner. If it were, then the state would itself be a kind of criminal. The state, however, must be impartial and attempt to balance out the wrong that has been done by making it right, by rectifying. And that process of rectification is up to the judge in accordance with the facts of the case. That being so, in order to ensure that the judge is not making law, is not in the process of doing what the Parliament should do, every decision must be spoken, must be a reasoned out order. These are the facts of the case. This is the minimum and the maximum. Given the heinous cruelty shown by the criminal in this case, we must award the maximum sentence, which is death. Or, given the fact that there were many extenuating circumstances, the terrible poverty of the criminal, the harsh upbringing, the circumstances that he was constantly abused by the victim or something like this, we may award the minimum penalty in this case. So it's very clear that the IPC is open to a great deal of interpretation in the meting out of punishments, even when minimum and maximum are set, to ensure that the law functions as a rectificatory and due procedure. We have to ensure the impartiality of the judge, and that just because the criminal happens to be a particularly heinous person, we don't want that the judge's animus is what is responsible for the high sentence or the death penalty. So if the judge reasons out his decision, it's open to everyone to see, yes, this is the minimum and the maximum provided by law. The judge has applied the minimum or the maximum through a rational process that all could agree upon. And this is what's determined in various appeals. So when a later court looks at the judgment, the later court looks specifically at the reasons behind which the judge applied a certain standard, giving a maximum or a minimum. So these are the broad ways in which the death penalty is forced to conform with the ethical theories about punishment that we had opened with. The judge is not there simply to retribute, simply to inflict harm on the victim. The judge is there to balance and mix the considerations of why the crime was committed. So perhaps we need to rehabilitate this criminal. Perhaps this criminal is so hardened that all we can do is protect society from this person. This is the, let's say, the third murder of this person, and we finally, the police have finally managed to capture this person. This person has been committing murders over the last 20 years consecutively, or something like this. There's really no point in rehabilitation. This person needs to be kept away from society. So we have to keep the welfare of society in interest. Through mixing and matching the ethical theories, the judge, in coordination with what Parliament has set out, employs various ethical justifications for the punishment that is meted out. And this is how the process of law and judicial decision-making works. A balance between the moral theories that justify, the legal consequences that the Parliament says follow, and the consideration of the facts of the particular case. Only in this way can we come to a just and rational punishment for a crime. The death penalty, as we've mentioned, is the most extreme. That means that we can only reach the justification for the death penalty if the ethical theories allow it. The death penalty accepted, the Indian penal law has uniform punishment for all crimes, which are supposed to simultaneously act as deterrent and as corrective. But there is no rehabilitative process in the death penalty. You're not rehabilitating someone, you're destroying their existence. The convict is deprived of freedom and comfort by being jailed for a certain period. The prospect of such deprivation is supposed to act as a deterrent, as well as keeping society out of arm's reach for a while. And the fact of deprivation is expected to engender in the convict a state of remorse that may act as a corrective. So this is why we imprison people, this is why we punish them. In the death penalty, once again, on the contrary, there's no possibility for rehabilitation, for correction, for a person to live a different life. That person dies as the consequence of a crime that is only supposedly rectified by the death and not the improvement of the criminal. Most countries are in the process currently of reconsidering whether the death penalty should ever be meted out. Recent cases in India have brought this to public discussion and a lot of public debate. What we find is that there are certain cases where people are deeply in favor of the death penalty, even in occasions where it is not usually carried out. The Nirbhaya rape case in 2012 saw that a 17-year and 6-month member of this group that gang raped and murdered a young woman in South Delhi, that because he was just 6 months short of majority, instead of being given the death penalty like the others, he received only 3 years in a juvenile detention facility. Think of the difference between 3 years in a juvenile detention facility and the sentence of death. And this vast difference derives only from 6 months of difference in age. Is this person really any less responsible for his crime because he's 6 months younger than 18 years? So on the one hand, we have cases where we think that the death penalty ought to have been imposed if justice were to be done, considering that other people suffered death for the crime. Obviously, we can debate whether anyone should have been put to death. Some people say the death penalty is never justified and they should have suffered life term of imprisonment. Even according to that standard, 3 years in juvenile detention versus a life term in imprisonment is very radically different. So there are various considerations in what is known as due process. On the other hand, there are cases where people are put to death and we think that they certainly ought not to be. Recent cases have shown this not only in India but around the world at large. These also can be understood to have due process considerations. Were these people put to death because of prejudice on the part of those who convicted and sentenced them? Are we to find later that the evidence according to which they were sentenced to death is weak and perhaps they were not even the guilty party? All of these considerations lead countries more and more to pull back from the use of the death penalty. In India, the debate is still open, but it seems that for the most part, the government is intent on retaining the death penalty for some time to come. In conclusion, the reasonableness, in other words, the moral justifications of the death penalty is quite questionable. After all, there is no empirical evidence that has conclusively established that the death penalty, in fact, deters people at large from committing the crimes that it is supposed to deter them from committing, according to the deterrence theory of punishment. So most of the justification for the death penalty is that this person has committed a crime so heinous that we could not possibly want other people in society to think that they can get away with something like that without being put to death. Now, that's the theory, but what happens in practice? Do we find that in countries that practice the death penalty for murder, let's say, that murder happens less in those countries? Empirically, this should be the case if the deterrence theory were sound and correct. So in country A, we use the deterrence theory to say that we will put a murderer to death in order to prevent other people from murdering. In that country, we should have a lower rate of murder than in a country that says we will not put a person to death for committing the crime of murder. Because the deterrence theory says that by not putting a person to death to deter others, other people are more likely to murder. What we find is, between countries that have the death penalty, there is no causal relation between imposing harsh penalties and reducing the level of crime. In fact, many studies show it's precisely the opposite. In countries that routinely execute, the crime rate is far higher than in countries that avoid the death penalty altogether. Now, we can't say there's a cause and effect situation here, because obviously countries that routinely execute, with the exception of the United States, are generally developing countries and poorer nations. On the other hand, we can call into question the deterrence theory as operating at all, unless we have sound evidence that putting someone to death deters others. Then why do we take this most extreme form of punishment? After all, we can never take it back once we've done it. So in the contemporary age of human rights and humanitarian sentiments, the trend of enlightened public opinion is definitely towards the abolition of capital punishment and replacing it by other forms of government. While this might be enlightened public opinion, it is certainly not the opinion of many regimes, the United States and India being two that don't foresee the abolition of the death penalty anytime soon. Thank you.